Hello, and thank you so much for coming to this presentation. My name is Donald Garrett, and we will be discussing the Code of Professional Responsibility for Parliamentarians. This is a pre-recorded session. However, if you are watching this live, please make sure to have your cameras on the entire time if you want to get a continuing education unit for the RP or PRP credential with the National Association of Parliamentarians. Your group that's viewing this has gotten approval for that, and that is a requirement to have your camera on because the NAP Commission on Credentialing does double check to make sure that you are present throughout the entire workshop. If you're not viewing this as part of getting a CEU, that's fine. You can still leave a comment below and whatnot if you have questions, and we'll get back with you. But please definitely contact me if you're interested in getting this set up for a CEU. We'll be taking questions at the end of this presentation. So please leave your questions in the chat or leave a comment. And when I'm doing the live portion, I will come on and answer those questions that you may have. But without further ado, this is today's topic. We're talking about the Code of Professional Responsibility for Parliamentarians. And it's important that we refresh ourselves about the code because every NAP member who's a parliamentarian has to abide by it, and we're going to learn about it. So the learning objectives today are straightforward. First, I'm going to introduce what is the Code of Professional Responsibility for Parliamentarians to you. Next, I'm going to explain NAP's process for enforcing the code. Then we're going to apply the code to a demonstration of an actual meeting situation that happened. And then we're going to learn where to find that written guidance from the NAP about how to comply with this Code of Professional Responsibilities. Finally, we're going to review and reflect on what happened and hopefully answer any questions that you may have about the Code of Professional Responsibility. The Code of Professional Responsibility of Parliamentarians was jointly adopted by the National Association of Parliamentarians and the American Institute of Parliamentarians in 2001. Those are the two largest organizations dedicated to parliamentary procedure. Both organizations revised the code in 2020 and made substantial updates. For one, it used to be called the Code of Ethics, but now it's the Code of Professional Responsibility. What's important to note is that all NAP members are required to follow this Code of Professional Responsibility. It doesn't matter if you are a regular member, an RP or PRP, you're paid or unpaid and whatnot. If you're a member of NAP, you're required to follow this Code of Professional Responsibility. The NAP bylaws, Article 3, Section 5 states members shall abide by the NAP bylaws, standing rules, and the Code of Professional Responsibility for Parliamentarians. And so that is an unqualified phrase in our bylaws. It just says members, so members have to abide by it. And that's part of the responsibilities of being a member. You pay your dues. You're able to say you're a member of NAP. And if you're going to say you're a member of NAP, you have to operate ethically as a member of NAP, which means following the code of professional responsibility. Now I'm going to show you how to find this code. And it is simple to find, and it's on the NAP website. And so you're going to go to the NAP website, which is parliamentarians.org. And then hover over the About section, and then there's a menu item that says Code of Professional Responsibility. You will click there, and there's information about the Code of Professional Responsibility. And then at the bottom, there are three buttons. One is a link to the code itself. Another is a link to the rules for how NAP processes those complaints about the code. And then the final button is a button just about the complaint form. And so if you click the Code of Professional Responsibility button, it's going to pull up an entire PDF of the code. And you'll note that the PDF is about 2.5 pages. There's some footnotes and whatnot. So it's honestly about 2 pages PDF. And you'll see that there's different sections to the code. And what we're going to do is in the next slides, I'm going to go over the various sections. And then again, if you have questions, please put them in the comment, leave a comment, or put them in the chat. And so with these various sections, these are all things that people can actually submit a complaint that alleging that you as an NAP member are not following the Code of Professional Responsibility. And so now I'm going to go through the various sections, and you'll note that in these sections, there are four sections. The first one really deals with aspirational standards we'll talk about. The next one deals with professionally responsible standards within our profession. The third deals with responsible standards related to obtaining appointments. And the final is standards in relation to clients. And the question is, why do we even have a code of professional responsibility? And that's important that we have this sort of code because when we as parliamentarians are out in the public and we're answering questions to people, whether or not we're an RP or a PRP, we want people to know, we want the public to know that, okay, these are ethical standards, professional standards that these members of NAP are abiding by. It uplifts us as a profession. It uplifts us, even if it's just a hobby that you have, it uplifts us and says there's a minimum ethical standard by which all NAP members abide by. It's also just important for just promoting us as a profession as a whole as parliamentarians. Because, for example, professions like lawyers, accountants, CPAs, engineers, doctors, etc., they all have ethical standards and professional responsibility codes they have to follow, right? And you can file complaints if that doctor, engineer, lawyer, etc., is not following, practicing, and abiding by those codes. And so, as a result, we have the same thing here with NAP, right? It's just like any profession, being a member and saying you're a credential member, being associated at the higher echelon of parliamentarians out there. It's important that we all abide by the minimum standards that we have and that represents us as an organization as a whole. The first section of the Code of Professional Responsibility really deals with aspirational statements. And when we say aspirational statements, these are statements that we should all strive to achieve and abide by as parliamentarians and members of NAP. The key to note here is that these six aspirational standards, you cannot have a complaint filed against you for violating one of these. And so they're aspirational in that way that you can't get in trouble for not meeting the aspiration. And going through each of them, the first one is saying, upgrading and improving the profession. And then we have maintaining integrity and competence in the profession. We have maintaining high professional standards and keeping abreast of the latest research in our field, promoting a spirit of cooperation and professionally responsible practice, conducting oneself as to reflect credit on the profession and inspire confidence and respect and trust in the clients and the public, and encouraging non-discriminatory standards in all aspects of parliamentary procedure. So what that means is someone can't write a complaint and say, oh, well, Donald, he rolled his eyes at me at the convention, and so I believe he violated the code because he did not promote a spirit of cooperation. He rolled his eyes at me. Those sorts of complaints are not allowed. And so these are very aspirational things and things that we should all strive towards. And so keep that in mind when you are a member of NAP and you are helping someone with answering a question, helping someone with the parliamentary procedure question they may have. The next section are professionally responsible standards within the profession. And so these really deal with how we relate to other parliamentarians. And the first one says refrain from misrepresentation or other conduct that may reflect adversely on the profession. And so don't do fraudulent things, don't do misrepresenting things and whatnot. That's going to make all parliamentarians look bad, right? And so, for example, if you are on the board, serving the board as a parliamentarian, and you're stealing money from the organization and whatnot, and that gets found out, like that could be grounds for removal from NAP. And so, because that's making us look bad as parliamentarians, as people who have inside knowledge about what happens in board meetings, and if you're going to take advantage of their internal controls. Things like that. The next one, refrain from knowingly or recklessly making untrue comments about the work, knowledge, fitness, or other qualifying aspect of another parliamentarian. And so the key here is untrue, right? And so you don't want to say false things knowingly or recklessly about other parliamentarians. For example, if I am trying to get an appointment as a parliamentarian and I say, oh, well, I have a master's degree, but so and so only has a bachelor's degree, right? You should hire me because I have more experience. That sort of thing is okay because that's not untrue if it's true that I have a master's degree and that person only has a bachelor's degree, right? So that sort of thing would not violate this section of the code. However, if you're walking around saying, "Don't hire Donald, he's a drunk and shows up drunk to all his meetings and whatnot," unless you have proof of, my blood alcohol level, a DUI report, or something, you can get in trouble for that because you are saying really recklessly untrue things about me, and I'm a parliamentarian. And so, if you're gonna speak about another parliamentarian, you make sure it's a true comment, especially if you're making comments about their work, knowledge, fitness, or other qualifying aspect. Next, 2.3 is sort of a catch-all. It's a big one, but it says you have to, one, report to the Professional Development Committee any known violation of this code that represents a material threat to the perceived integrity of the profession. And then also you have to provide testimony and assist the committee if there's like investigation. And so again, if you know of a violation of this code that's going to represent a material threat to the perceived integrity of the profession, you have an obligation to report it. This is not things like, oh, well, Donald was in this meeting and they forgot to get a second on this motion, right? Those sorts of things are not a material threat. But if you see me at a meeting, I'm the parliamentarian, and I'm okay if the chair disallowing half the room not being able to vote and whatnot, or I'm answering the question and say, oh yeah, this requires a 5/6 vote when it only requires a majority vote, and that's really impacting people's membership rights. Like that could rise to the level of I need to let NAP know because this is a PRP going out here spreading lies, right, about the procedure, about the parliamentary procedure. And so you have an obligation, if it's of especially material threat to the profession, you have to report it. And finally, 2.4, refrain from violating or attempting to violate any standard contained herein through the acts of another. Don't get people to do your dirty work for you. That's what this is saying, basically. And so I can't tell my sister, hey, sister, go say this untrue thing about so and so, right? So I can get the business. Then if they find out that that's my sister and I set her up, that I could get in trouble for her acts. And something I do want to note is that I'm going through the various sections of the Code of Professional Responsibility. However, you could almost do a whole hour-long presentation just on one of these sections, but I'm just doing a brief overview of all the different sections so you have a knowledge and awareness of them. Section 3 deals with the standards related to obtaining appointments. And note that the verbiage used, it says obtaining appointments. So this does not mean it has to be a paid opportunity. It could be unpaid, right? And it's just about obtaining the appointment to serve as someone's parliamentarian. And so 3.1 states that parliamentarians shall not knowingly or recklessly misrepresent your parliamentary credentials, education, or experience, right? And so there is no misrepresentation or lying allowed when it comes to getting business from other individuals and other companies and other entities. And so be truthful about your experience and whatnot, because if it's found out, you could actually get in trouble. If a client is not happy with your work and they say, oh, well, he said he had a PhD in parliamentary procedure and he was NAP president, like, what? He wasn't good. Like, I mean, what is this about, right? And they find out, and the NAP finds out about that, you can be held responsible for this code violation if you've misrepresented your credentials to get a client. 3.2 says refrain from giving anything of more than nominal value to anyone for recommending your services, except for the reasonable cost of advertising, the usual charges for a referral service, and payment for the purchase of a parliamentary practice. And so the key word here is nominal value, right? And so if you're getting recommendations for your for services, you can't pay someone lots of money to do that like for you. And so we're only allowed to do nominal things. But then there's the three exceptions that follow after that. And so nominal value, if someone recommends you for a role, you can give them like a thank you card, right? That's nominal. Even like a $5 Starbucks gift card. That sort of thing is fine. It's to thank someone for recommending. But as soon as you're, taking them out for lobster dinners, sending them $1,000 checks and whatnot, that's rising above the level of just the nominal value. And so that's what we have to refrain from doing as parliamentarians. And that's, remember, getting all appointments, whether that's paid or unpaid. The exceptions to that rule include one, the reasonable cost for advertising, right? And so if you are advertising in online, print, journal, etc., you're allowed to pay for those services in order to get recommendations for parliamentarian services. If there is like a referral fee that you typically usually would pay someone for getting services like a headhunter or something like that that goes out and like finds you business, that sort of thing's okay. Or you might just buy the client off someone because sometimes if someone's retiring and have a client book, you can say, let me just buy the client book off of you, and then I'll take over your business, right? Or you just make sure you recommend me to the clients and I will succeed you as their parliamentarian. Those sort of things are fine. And then also what's fine is just things that are a nominal value. But other than that, you have to refrain from doing that when you're really trying to obtain your clients and obtain appointments. 3.3 says decline any appointment that the parliamentarian knows or should know that the parliamentarian is not competent to handle. I personally think this one's kind of hard because how do you know what you don't know, right? And I think one way to sort of defend against this one is you really use your NAP network. And to me, one of the nicest things about being an NAP member is that you meet different people and their different organizations that are all at different levels, right? And so if you feel uncomfortable taking on an opportunity, but you think you might be able to handle it, you're on the fence, I would just reach out to a more seasoned NAP member, a more seasoned parliamentarian, and say, hey, if I take on this client, if I have a couple of questions, can I just pick your brain if that comes up? That sort of thing is perfectly fine. Um, and so that's going to allow you to have that peace of mind, peace of assurance. And the one thing about NAP members, we are nice people. I've helped out people, people have helped me out, etc. And so those are all things that you're able to do in order to make sure that if you're on the fence about not being able to handle something, that you can at least have that assistance there. And 3.4 says decline any appointment in which a parliamentarian is likely to be unduly restricted in the exercise of independent professional judgment. And so that can come up in a few different ways. Some examples that come to mind might be if you have a family member like a spouse or a sibling that's like on the board, right? And then you're going to be their parliamentarian. People might say, "Hey, like, is your advice really independent because that's your spouse or that's your sibling, right?" They could reasonably raise that question because they're expecting an independent professional judgment and advice that you're giving to them as a parliamentarian. Other instances might be if you have a financial stake, right? If you have, a lot of shares or a unit in like a company, and there's instances about maybe steering the board to approving buying those shares or a major sale and things like that. There could be questions about your professional judgment if you are giving advice that's going to line your pockets because you're gearing the board guiding the board towards a sale that's going to allow you to sell your assets, right? And so those are just all things to keep in mind, and just know that you should decline if it can be challenged if it can be challenged that perhaps you are restricted from giving truly independent professional judgment and advice to a client. So Section 3 dealt with obtaining appointments. Section 4 deals with us and how we relate to our clients. And Section 4 is the longest, but it's going to be divided up into 3 slides, but we're going to go through each one. So the first one says, prepare adequately and act with reasonable diligence and promptness in providing service to a client in accordance with any agreement with the client. And so that's important because if you are hired by someone and you take 3 weeks to respond to email messages, they can go to NAP and say, "Hey, we need help, and we couldn't reach Donald, right?" And so you want to make sure that you are uh, doing due diligence right. So that's it's a balancing test, right? Because on one hand, you want to have due diligence, right? You want to make sure the answers that you give are researched and correct, and the other hand, you want to also make sure that they're prompt. Another key phrase in this section is that these standards are going to be in accordance with any agreement with the client. And so that's why also it's important to have like a written agreement, or even if it's like a MOU or a bullet point list of what the expectations are that say, hey, you can reach me by phone or email. I tend to respond within 2 business days, at least confirming receipt. Things like that, right? You're able to point to and say, well, this was in my client agreement. And so they knew the customer service expectations that I was going to give. 4.2, advise the client on the proper application of the accepted rules of parliamentary procedure. That's the big one. Basically, make sure you are correct when you are giving advice about Robert's Rules of Order. Otherwise, especially if you have a client, it can be challenged and a complaint can be filed and it can be adjudicated from the Professional Responsibility Committee. So keep that in mind. 4.2 is important because we are making sure we're advising the client appropriately on parliamentary procedure. And 4.3 says, do not accept gratuities or favors that might appear to warp professional opinions. And I keep this in mind when I have a paid client because, for example, if I am serving a convention, but then they have like a welcome meeting or a welcome like reception or dinner on Friday night before the Saturday morning convention, I and someone who's running for like an office or whatnot, they might say, "Hey, Donald, let me buy you a drink. Let me get this drink for you." I will decline it because at the end of the day, like I don't want anyone to see that and say, "Oh, well, they were buying Donald drinks last night. Is that why Donald got the presiding officer to rule this way?" And so I try to not accept any gratuities or favor, especially if it's paid. If it's paid, I'll pay for my own things out of the money that you're going to pay me for my services, right? And so don't accept those things. Especially then, even if it's like at a dinner, right, and everyone else is having hot dogs, but they get you the lobster and the filet mignon. In that instance, you might decline that as well too, because you don't want to be seen as giving these favors and gratuities and whatnot that might warp your professional opinions. And so, if we're eating out and whatnot, I make sure that I'm not getting anything more extravagant than what anyone else at the table is getting if it's covered by the organization. And so you want to just kind of avoid things like that. 4.4 is the longest one, but it's simple. Basically, keep things private and confidential about the information that you have obtained in your professional service, in the course of your professional service. Keep things confidential, right? And then the exceptions to that are informed consent from the client, to the extent necessary to prevent or report criminal or fraudulent activity, to secure professional advice about compliance with this code, to establish a claim of defense, or to respond to allegations about this to or respond to allegations about this to or to comply with the law or a court order. This is another area that where if a client sort of has like a confidentiality clause and like an agreement that we have, I make sure to put in there that if this is something that's like in the public domain, like if I can Google it and find out the information, then it's not secret, right? And that should be I'm free to talk about it. And so I've had that happen to where this if someone like asks for like an example of something that happened at like a meeting. If this organization is one that publishes their minutes and recordings of the meetings like on the internet, I'm free to talk about it because it's all on the internet. I can talk about it, right? But if they're not an organization that does that, then I can't really discuss it because as a parliamentarian, we have to keep things private and confidential. Something that's important here to note is that you are allowed, to the extent necessary, to release a little bit of information to secure professional advice about compliance with the Code of Professional Responsibility. So this goes back earlier when we were talking about 3.3 when it talked about not being able, you should decline appointments that you aren't qualified to serve at. So, like again, if you need like a mentor or some help with that, you're allowed to ask another parliamentarian professional advice to make sure you're complying with this code. Because when we're complying with this code includes advising the client on the appropriate use of parliamentary procedure. And so we are allowed to ask for help for that. You can also pose questions to the Professional Standards Committee if you want to get some advice on that. Um, and so again, I would the key word also says to the extent necessary, right? And so I would maybe not use exact names, maybe to say the organization or the board, for example, when you're getting help, as to make sure that you're not revealing too much, right? But that's you're able to do that. 4.5 says we were required to maintain a position of objectivity and impartiality and avoid participating in substantive debate to the extent required by the role in which the parliamentarian provides service. Don't enter debate. Typically we speak through the chairperson, and then if we ever have to like answer a question, or it's better for us to explain the procedural situation, if the chairperson is not good at doing that, then we can briefly do that, right? We are not supposed to participate in debate. Um, the one key word here says to the extent required by the role in which the parliamentarian provides service. And so there are instances where you might be what's called a floor parliamentarian when you are representing a cause like on the floor with your business during the business meeting and whatnot. If you're hired in a position of advocacy, that sort of thing is okay for you to like debate, right? Or if you're a parliamentarian who's a voting member on the board of directors and their bylaws allows that, then you might be able to uh, debate because you're also a board member. So that just depends. And so again, this is just to the extent required by the role. But just most typical independent parliamentarian roles require objectivity and no debate. An example I have from this, one time I was asked to be a professional presiding officer at a meeting. And this was a removal meeting. And they had a membership petition that required a special meeting and a petition to remove the whole board of directors. Um, since I was the one presiding during that meeting, the board president was able to more accurately, not, was more able to get involved in the debate and whatnot. And then one of the points he wanted to make during his speech was that this was a big waste of time and money over just a petty dispute because we have to spend money to send the notices out and make the ballots and get the consultants here and stuff like that, right? And so towards the end of his speech, he went kind of like group by person and said, management company, are you being paid to be here right now? And they said, yes, we're being paid. Lawyers, are you being paid to be here right now? Yes, I mean, we are being paid to be here right now. And temporary chair, are you being paid to be here right now? My response was, it's inappropriate for me to enter debate. So I did not answer the question. I said it's inappropriate for me to enter debate. And kept it going. And so that was my way of complying with this because had I said, "Oh yeah, I'm being paid to be here right now. I'm getting like whatever, whatever," that added to that person's speech, right? And that could have swayed people one way or the other. But I'm only there to preside. I'm not supposed to debate at all as an independent presiding officer. And so I just said I can't. It's not appropriate for me to debate. And they left it at that. So, I mean, they could take whatever they want to take. He could have said, like, oh, yeah, we're paying him too. I'm not going to respond to it. I'm just there to um, preside, right? And then if they got questions, they can put in financial requests or whatever to the organization if they want to learn more. But that's something I had to do one time. And then finally, for these last set of standards in relation to our clients, 4.6 says we have to make reasonable efforts to call to the attention of the client significant deviations from the rules that may have harmful rights, that may be harmful to the rights of members of the assembly as required by the rule of the parliamentarian. And so this is important because we have a duty that says if there's significant deviations from the rules, we have to let the client know. And that ideally is happening during the meeting, or, if it doesn't happen during the meeting, you send like a letter afterwards immediately saying, hey, uh, these are the things I'm going to bring to your attention. And so I'll do it a little informally, right? I'll just do like bullet points of just like a meeting debrief. And like, I would just say like, these are some things I noticed at the meeting. Please let me know if you have any questions. Especially again, these are significant deviations that could be harmful to membership rights. And so we have a responsibility and obligation to bring those to the client's attention. Make sure you try doing it during the meeting if you can. And if that means tapping the chair's shoulder and asking the chair to, pause while you talk to them about it, but that's what your responsibility is. And 4.7 says not we are not supposed to withdraw from employment without reasonable justification, without first taking reasonable steps to avoid foreseeable detriment to the client. And so we really need to, if you are committed to someone, you really need to make sure that if you're going to withdraw from employment, make sure you either have reasonable justification, or if you don't have reasonable justification, make sure you're trying to find like a backup, or you're pointing them to how to find a replacement, right? And so let's say there's a conflict of interest, and you found out your brother is running for president for the organization, so you might not want to be the parliamentarian just because, so there's like no bad blood. You might say, I have a conflict of interest. I can't, work with you anymore. Here's some replacements I can recommend, or go to the NAP website and find yourself a PRP, and you'll be good to go, right? So you're able to do those sort of things. So just make sure that you're just taking those steps. That you take reasonable steps to make sure that the client's still going to be okay, even if you withdraw from um, employment with them. So that was just an overview of the Code of Professional Responsibility. Now we're going to talk about how it gets enforced. And so the National Association of Parliamentarians has a Professional Responsibility Member Discipline Committee. And it is comprised of four members who serve four-year terms. And the four-year terms is important because that means the committee, only half the committee each year, each biennium cycles, right? And so NAP NAP works on a 2-year cycle, right? We work in a biennium cycle, and so that means when a new president comes in, they can't just appoint the full committee; they can only appoint half the committee. And so that makes sure there's continuity. That makes sure there's continuity and fairness on the committee membership, just to make sure that they keep help with their independence. So this committee is responsible for receiving and adjudicating any complaints about violations of the Code of Professional Responsibility and its membership discipline things in general. And so the committee, they have the power to issue reprimands, but then the committee can also recommend to the board of directors that someone be suspended, or that their membership or credential be revoked or suspended. And they can recommend to the board, but they can't vote on it themselves. And in a few slides, we'll go over what sanctions they have available. And so there are earlier we discussed where you can find the rules for processing complaints about the professional responsibility code. But again, this is a code that we're all NAP members are required to follow, and anyone can file a complaint against you if they believe they want to allege that you're not following the code. That could be another NAP member, that can be a client, that can be a former client, etc. And so it's important that we abide by it, and these are going to go through the rules for how these complaints get processed. So number one, the complaint needs to be sent within a year of the event of when the complaining event happened. It has to be sent to NAP headquarters. And these are sent by mail to NAP headquarters. And they do that because they keep things confidential. And so you're supposed to put it in a separate envelope, a double envelope, right? So that when NAP gets it, they don't open, when they open it up, they only see the complaint in the envelope, and then they take the contents and they forward it to the Professional Development Committee, right? So that means staff doesn't know what's in it. That means the board doesn't know what's in it. Only the committee knows what's in it because they're the ones responsible for it. And so the complaints are sent to NAP, and the event that you're complaining about has to have happened within the past year. Next, the Professional Responsibility Committee, they conduct the initial review, and then they'll request a response from the responding party within 30, and they want a response within 30 days of that request. And so they will review the complaint and maybe ask questions and figure out any questions they may have, and they provide a copy of the complaint to the responding party, the person the complaint's about, and then gives them the opportunity to respond in writing. Um, when you respond in writing, you're able to submit your documentation, right? Be like, I didn't take a steak dinner. Here's my receipt for Chick-fil-A that night, right? They're able to submit the receipts, and you can just show give your side of the story. After that, the committee takes both sides, right? They take the complaining side, they take the responding side, and they review and deliberate, and then they determine if there needs to be any further investigations. There might be follow-up questions, they might be trying to weigh people's credibility, trying to weigh the evidence, etc. And so they will do that. They'll take what was done and just make sure that they have what they need in order to make a decision, because that's the next step. The committee then decides, based on preponderance of the evidence, whether or not a violation of the code occurred. Preponderance of the evidence means more likely than not. So that means about 51% chance that this event occurred. And so that's important to note because they want to make sure that based off the full evidence, that's center evidence that they're using. Next, if they find that a violation has occurred, then the committee can either issue a sanction or recommend that the board issue a sanction. And so we'll go in the next slide, we'll go over what the sanctions are, but that's what they're able to do as a result if they did find a violation. And then finally, they publish a redacted ruling or a memo on the NAP website. Um, and then you can also have the right to appeal your ruling to the board of directors of NAP if you'd like to. But it's important that you have copies of these rulings from the committee because we as members need to know, okay, like how do I respond to the how do I comply with this code, right? Like what are examples of good behavior and bad behavior, and that allows the committee to set a precedent, right? Additionally, a lot of the times the work we do as parliamentarians, we are not like in the room looking at other parliamentarians. And so because some of the work we do is private, and so they want to make sure that there's an opportunity to still educate people on how to comply with the code and what's good behavior and bad behavior. And you do that by being transparent about the rulings and whatnot that you have made. And so, if there is a violation of the code found, the committee can issue a few sanctions. And this is based off of the rules and code, the rules and policies that we have in NAP. First, they can close the file and this issue what's called a confidential letter of caution, where they're not going to publicly say anyone's guilty of anything, but they'll say, hey, these are things that we noticed. They didn't rise to the level of you needing to get in trouble, but like keep this in mind for the future, right? They're able to do that. Next, they can issue a reprimand, and they can reprimand you as a member of NAP for what you did, and they can require you or not to issue an apology as a result of the reprimand. And so you could actually be required and ordered to apologize to your client or to whomever or to the person that you made bad remarks about and whatnot if the committee thinks that's an appropriate sanction. Next, the committee can sanction you with remedial actions. And that can be anything from you requiring you to take different additional training or to redo the PRP qualification tests and things like that, right? If they think that that's the sort of thing that would help you learn what you need to learn, and to make sure you're giving a good parliamentary advice to people. Next, the committee can recommend that your credential be suspended or revoked. The committee itself does not have the authority to suspend or revoke credentials, but they can recommend to the board of directors that that be done. And then the same thing can happen to membership, right? They can ask the board of directors to either suspend or expel people from membership. And so that might be a way, right? Because if someone is making NAP out to be a bad organization, right? NAP can say, we don't want you in an organization anymore. And so that is sort of the process that you have. And these are the sanctions that you have in response to an alleged violation of the Code of Professional Responsibility. Additionally, when you have a complaint filed against you, outside of those sanctions and the rules they followed, the procedures also do list different grounds for dismissal of the complaint. And the first one is the complaint is untimely. Remember, the events had to have happened within a year of filing the complaint. And so if you're going to file a complaint about something that happened 5 years ago, the committee is going to say, this is too old, we're dismissing it, right? And so that's a key line of defense that you have if you think if a complaint has been filed against you and you think it's untimely. Next, if the complaint concerns part one of the code of professional responsibility, then um, it's also dismissed because remember, those are aspirational and you can't have a valid complaint against someone for not abiding by those aspirational sections of our code. A complaint can also be dismissed if it is found to be redundant, right? If I've submitted 5 complaints about the same issue, hoping to get a different result from the committee can say, we already decided this one, the other 4 are dismissed, like leave us alone. Next, complaints that are frivolous, inconsequential, or not attain the required level of proof can be dismissed. And so, frivolous things, like I said, could be, oh, well, Donald gave a wink to someone at the meeting, and I thought that, that was a favor or gratuity that shaped his opinion because someone winked at him, right? That might be frivolous. Or, Donald did not shake my hand. Um, did not shake my hand when I asked him a question afterwards at the meeting. And so he was a bad parliamentarian. Like those are things that be frivolous. I mean, unless there's like some sort of other thing that like goes with it. If it's a frivolous complaint, those get dismissed. And then finally, if the committee found that the respondent actually acted properly, then they can dismiss it, right? And so, for example, if the parliamentarian pulled the president aside and said, "Hey, you can't do this," and then the president files a complaint saying, "Oh, the parliamentarian was so mean to me, he pulled me aside and said I couldn't do it." You could tell the committee he couldn't do it, and so the committee might agree with you and dismiss the complaint. And so, like I said earlier, the committee actually publishes written opinions about different cases that have been before it in order for you to learn about their thoughts on how to comply with the code of professional responsibility. And so now I'm going to show you where to find that information. We're going to go back to a web browser. And then instead, this is a members only sort of thing. And so we're going to go to the NAP portal. So you're going to click on the very, very top header where it says NAP portal. And it's going to take you to a login page for that. Login is at the top right-hand corner. You're going to log into the portal. And then once you're logged in, we're going to go to the document library. And how to find that is at the top right. You're going to hover over, you're going to click on your name. And then it says My Digital Library. You're going to click on that. And then you'll see here there's various resources that you have as an NAP member. And you'll note there's actually 10 folders. He says one of 10 at the bottom. There are 10 folders to choose from. So you might need to look at all 10. And you'll see that here it is, professional responsibility complaint summaries. And so you can click on that. And then if you note, you can look at the date. See, this one says 2022, December 31. I mean, like look at the date of all these various complaints that they ruled on. And if you need to expand how many you see on a page, you can do the items per page and you can expand that. Because look, there are 25 complaints available for us to look at. And so this could be some reading for you if you just want to learn more about what you shouldn't be doing. And then if you click on the first one, for example, and it's going to open up a PDF file or download a PDF file, which you can open. And you'll see there's just information about the complaint summary. So here, for example, the committee decided to dismiss this complaint. And so that is that example that we have there. And so again, these written opinions are available on the NMP portal. And so what we're going to do now is we're actually going to go through one of those written opinions. And I'm going to read you a situation that's based off of written opinion. And then I'm going to maybe count to about 30 or so, or then maybe you can pause the video if you want to. And I want you to kind of type out what you think was good or bad about the situation, and if the parliamentarian acted in a way that violated any of those rules that we had talked about. And so here's the situation that happened. This situation happened at an association meeting. During the meeting, the presiding officer ordered that members be removed. The parliamentarian was present but did not confer with the chair at any point while the removals were taking place. Members attempted to raise concerns, but no opportunity was given for this and they were quickly shot down. This entire sequence was captured on video. The recording shows that no motion was made and no vote was taken regarding the removals. Instead, the chair acted on her own authority, instructing members to leave the meeting while the rest of the body looked on. The meeting continued with several members absent, leaving the impression that the removals had been carried out unilaterally outside of the group's normal decision-making process. And so I'm going to count to about 20 or 30 and give you some time to type a response in. So I want you to type in the chat or leave a comment what you think uh, was bad about the situation, and if you think any sort of code had been violated. And also remember, you can pause the video if you need more time. Okay, so we're going to move forward. And so this situation deals with removing members from a meeting. And we're going to go through what Robert's Rules of Order has to say about that. So under Robert's Rules of Order, kicking someone out of a meeting really depends mainly on their status, membership status, if they are a guest or if they are a member of the organization. And then if they're a member of the organization, removing them depends on whether or not it happened during the meeting, if the behavior that got them removed happened during the meeting, or if it happened outside of the meeting. And so we'll go over the difference first. And so we'll first start with non-members and guests. And so Robert's Rules of Order says that the chair has the power to require non-members to leave the hall or to order their removal at any time during the meeting, and the non-members have no right of appeal from such an order. However, such an order may be appealed by a member. Additionally, so that was in section 61, paragraph 19. Additionally, earlier on in the book in section 9, it says some bodies, especially public ones, may invite non-members to express their views, but this is done under the control of the presiding officer, subject to any relevant rules adopted by the body and subject to appeal by member. And so here, in this situation, if it's a non-member, the chair does have the authority to remove non-members from the meeting. Roberts does give the chair that authority. However, anyone, the group as a whole, can say, hey, no, let that person stay in our meeting. And so that's something to keep in mind with your meeting chairs, that that non-members who are invited guests and whatnot are able to only be there so long as the chair allows them. However, in the sample situation that we're talking about, that is dealing with members of an organization. And so let's see what Roberts has to say about removing members from a meeting. And so first, look to Section 25. That actually deals with suspending the rules. But Section 25, paragraph 11 says rules protecting a basic right of a member cannot be suspended. Thus, while generally applicable limits on debate and the making of motions may be imposed by such as adopting the previous question, the rules may not be suspended as to deny any member the right to attend meetings. These basic rights may be curtailed only through disciplinary proceedings, right? And so Roberts says that attending a meeting is a basic membership right. You can't suspend that. That right can only be effected if it's through disciplinary proceedings. And so from there, we have to now then go to the back of the book, the very last chapter, which talks about discipline and what happens with that, right? And so if I'm going to take away someone's right to attend the meeting, there has to be something, they have to be doing something wrong. So in the back of the book, the last section of the book, 61, 62, deals with discipline. And Roberts really has a three-step process for when it comes to membership discipline, especially for transgressions that happen during a meeting. So the first strike says really just give the member a warning. So 61:10 says if a member commits only a slight breach of order, such as addressing another member instead of the chair of debate, or in a single instance failing to confine his remarks to the merits of the pending question, the chair simply raps the gavel, points out the fault, and advises the member to avoid it. The member can then continue speaking if he commits no further breaches. And so Roberts says, strike one, these slight breaches of order. The chair just says, hey, you're breaking the rule, don't do it again. That's what the chair is supposed to do when it comes to disciplining someone for something that happens during the meeting. Next, you get strike two. And strike two is really the chair, before the chair even kicks someone out of the meeting, the chair just gets them to be seated at that point, right? And how does that happen? Really, the assembly is the one who orders that. But how does that happen? If we look at the next paragraph, this is 61:11. Remember, it even starts off saying the chair should normally first warn the member, right? And so that goes back to strike one. Please first warn the member. But with or without such that warning, the chair or any other member can call another member to order. That's essentially a point of order that you're making about a member violating the rules. If the chair finds the point of order is well taken, he declares the offender out of order and directs him to be seated. If the offender had the floor, irrespective of who originated the proceeding, the chair clearly states a breach involved and puts the question to the assembly, shall the member be allowed to continue speaking? This question is undebatable. And so here in this instance, you have the membership voting on whether or not the member shall be allowed to continue speaking. And so here, for strike two, the chair says, please sit down, and we're going to let the assembly decide whether or not you're able to continue speaking in debate. And so that's important to note here because that's not what happened in our video, in our demonstration, right? In the case study that we talked about. And so keep that in mind for strike two. And again, strike two, no one's being kicked out of the meeting just yet. They're just being told you can't be, the assembly is just voting to keep you from speaking. Strike three is when you can issue the penalty, right? And so again, Roberts goes on and says, in cases of obstinate or a grave breach of order by a member, the chair can, after repeated warnings, remember, after repeated warnings, name the offender, which amounts to preferring charges. And then again, this should only be resorted only to in extreme circumstances. And so again, this is extreme circumstances, repeated warnings. You are warning the person, you're giving them chances to comply. Otherwise, you're going to start issuing a penalty, which is like this last strike. And Roberts even gives the member one last chance. It says, if the member obeys at this point, the matter can be dropped or not as he simply chooses. The case may be sufficiently resolved by an apology or withdrawal of remarks. But if not, any member can move the order of penalty. And so in that instance, again, Robert says, hey, if you can informally solve this by apologizing and whatnot, that sort of thing is like fine. Otherwise, again, the assembly is the one who can order and issue a penalty. And what do we mean by a motion to issue a penalty? That motion can propose, for example, that the offender be required to make an apology, that he be censured, that he be required to leave the meeting hall for the remainder of the meeting, or until he's prepared to apologize, that his rights to membership be suspended, or that he be expelled from the organization. So there's a whole list of proposals and sanctions right there that you could offer. Again, that's a motion. You have to do a motion in order to kick someone out of the meeting for the rest of the meeting. Again, the offending member can be required to leave the hall during consideration of the penalty, but he must be allowed to present his defense briefly first. And so again, when you're issuing these penalties, these paragraphs, these sentences that we're talking about in Roberts talks about the assembly ordering penalties, not the chair. One other thing to note is that if you're dealing with a board meeting and not a membership meeting, the maximum penalty that can be imposed upon a disorderly board member is that he be required to leave the meeting room for the remainder of the meeting. Anything else, like the assembly as a whole, has to remove a board member. And so what did the committee think of that? And so we had what happened, right? What happened was we had a chairperson who was just kicking people out of the meeting and whatnot. People were kind of protesting, but the chairperson wasn't having it. The parliamentarians kind of sat there and whatnot. And so what did the committee think? Did the parliamentarian have a responsibility to do anything about this? I mean, it's not his meeting, it's up to the chair, right? And so let's see what the committee said about that situation with the Code of Ethics. I mean, the Code of Professional Responsibility. Right off the bat, the NAP member had the duty to respond and advise the president that she was violating membership rights. Wow, this from the beginning, right? Pardon me. And so the committee said the NAP member had the obligation to advise the president that this was wrong. I said from the video of the meeting, Contrary to what the member said, it is not seen whether the member conferred with the chair regarding the chair's significant deviations from the rules governing member removal. The video shows that the NAP member did not follow code section 4.6. And so they're saying the chair, one, the violation was the chair solely removed people from the meeting. Two, the parliamentarian did not advise the chair in regards to those membership protests and appeals about getting people back into the meeting. And three, um, members were actually removed from the meeting without even having a vote. And four, it shows that the video, there was no motion made or vote taken to remove any of these people from the meeting. And so we went over what Robert said. Robert said, if you're going to kick someone out of the meeting, you're going to impact their rights. Only the assembly has that authority, right? And so from the video, it was clear that the chair was doing this, and that was improper because only the membership can impose a sanction like that. The committee also said, please look at Robert's Rules of Order about the duties of the parliamentarian. It says it's a duty of the parliamentarian, as inconspicuously as possible, to call the attention to the chair any error in proceedings that may affect the substantive rights of any member or otherwise do harm. There should be an understanding between the parliamentarian and presiding officer. There will probably be occasions where it may be essential for the chair to listen to the suggestions being made by the parliamentarian, even if it means momentarily not giving the full attention to others or asking the assembly to stand at ease during this consultation. And so that's important because Robert says, as a parliamentarian, we have an obligation, and we also have the professional code obligation to say bring to the chair's attention when there are substantive rights being violated. I think in this person's situation, this was a video recorded meeting, and so it was pretty easy for the committee to see, oh, the parliamentarian is just sitting there, right? Um, And so there was no even attempt to say like, "Hey, can we talk, Mr. Chair?" Madam Chair, had that been on the video, they might have gone softer on the person, right? They could have like trying to get the chair's attention and whatnot. None of that was happening. This is just happening during the meeting, and I guess they didn't even send like a letter afterwards saying, "Hey, what you did was wrong" and whatnot. So they said, as a parliamentarian, we have the duty to let the chair know of these major errors. And so Rule 4.6, remember, says we have to make reasonable efforts to call the attention to the chair significant deviations from the rules that may be harmful to the rights of members of the assembly as required by the role of parliamentarian. And so if you look at that, again, remember, Robert said that attending a meeting is a basic membership right, correct? And then from there, since it's a basic membership right, the chair is getting rid of those rights and not the assembly. And so that was a really big issue. And then further, as required by the rule of parliamentarian, Robert says as a parliamentarian, we have to let the chair know when major rights are being violated, right? And so that's why they found a violation of this rule 4.6. And again, if you're in the chair, you still have to, even if you think it's pointless or useless, you still have to make the attempt to let the chair know of these rights being violated. And so the committee said we have a responsibility to do that. And I'd love to hear what your reactions are. Please leave a comment or type them into the chat. And so compliance tips. Number one, immediately speak to the chair. Try to get the chair's attention, or at least attempt to get the chair's attention, right? Don't just sit there and be passive. Like, you as a parliamentarian aren't just you're not just an observer. You do have a role with giving advice to the chair. Whether or not the chair takes the advice is one thing, but actually giving the advice is what you have to do. Next, if it's like such a really chaotic situation, you might send like a post-meeting letter afterwards just to document what you saw was wrong and whatnot. So you always have like a copy of that, copy of the email that you might send in case it ever is brought up. You have a copy that you can show someone that I did advise and share. They wouldn't listen to me, so I put it in writing. Next, try not to walk away if you can't. I mean, if it's something like kind of illegal or fraudulent going on, you definitely have the right to walk away from that. But for situations like this, if it's something that you can like work through with the organization, try to be your best to be helpful to them. And finally, you can also ask another parliamentarian or the committee for advice on what you should do. Remember, NAP members are nice, and keep it in mind when you are trying to seek help for complying with the code. And that's what I have for this presentation. So again, I'd love to hear your questions. Please make sure you type them in the chat and we'll go over them during the live Q&A if that's scheduled for your group, or you can leave a comment on the uploaded video and I'll get back with you. And I just want to thank you so much for taking the time to watch this presentation, and I hope that you learned something new.